Okay. Good morning, everyone. Welcome to AutismBC Talks. Today, our topic is Autism and Estate Planning with Geoffrey White. We are super thankful to have Geoffrey as our speaker today because we know that Geoffrey has a very packed schedule of seeing clients in his office and also traveling from Kelowna to Lower Mainland and back and forth. So introduction of Geoffrey. Geoffrey White has more than 25 years of expertise in will, estate, and trust matters. Geoffrey assists clients both in his heritage office in Kelowna and as counsel with Clark Wilson LLP in downtown Vancouver. So Geoffrey has contributed a lot in the estate and trust matters at all levels in BC. So if you want to know more about his bio, please read the email. And some housekeeping items. So today we will have an hour and a half with Geoffrey. The first hour, Geoffrey will do his presentation. And after that, we will have question and answer time. So if you have any question during the presentation, please type in the chat and I'll gather all your questions. And then we can ask Geoffrey the question afterwards. Okay, without further ado, I'll pass the time to Geoffrey.
Great, thank you, Stella. It's great to be here this morning and great to see all the people joining in to participate. So Stella, I've been admitting people as you spoke. There were a whole bunch coming in even then, but I'll pass those duties over to you to make sure that everyone's able to join in. It's just great to see the interest that is out there. I think that my experience and experience of the clients and the families that I work with is that these webinars are invaluable just to give you a little bit of exposure to what some of the laws are and what some of the concepts are, and to just prepare you to be able to know what the next steps are that you want to take. So first, I would say congratulations to you for taking this step. I know your time is precious and important. And so what I'm going to try to do is give you an overview of the planning that goes on for families in British Columbia that have a loved one who has a disability. I will try to customize a little bit of what I'm talking about to folks with the autism and the spectrum of autism, because that is the group that we're talking to this morning. And there are some unique characteristics that apply to these general rules when we're thinking about that. And as Stella said, we are planning to have just a presentation of this information for the first hour or so, but we wanted to leave a good half hour for questions because I think that's where we get a lot of value as well, being able to kind of clarify and make sure that we're all on the same page in understanding that. Sometimes we take those questions as we go along, but goodness, I think we're up to almost 85 people now. And so that would be a little bit challenging to do. So one question that came in that is relevant that I will answer right now, though, is about the slide deck. And yes, I will be providing this slide deck to Stella, and she will be able to distribute it afterwards. So you won't need to take specific notes on the information you're seeing on the screen, but you may want to take your own notes or just pump questions into the chat so that we can address those when we're done. So great. Well, let's jump in. As Stella has described, my practice for 30 years as a lawyer, 25 of those years here in British Columbia, has been in dealing with wills and estates and trusts. And a large portion of that has been working with families who are affected by disability issues. And, we've probably done planning for, several hundred, probably 400 or 500 families that are in these circumstances. And there are some common themes that apply, but every family is unique. And so that's why we've structured ourselves this way to give you the general information about the themes that you'll see across the board, but also give you the opportunity to kind of ask some more specific clarifying questions. So what I've got on the screen right now for us is just a brief outline of what we're going to do in today's discussion. So I'm going to talk generally about how the community supports or disability benefits in British Columbia work, what the rules are for qualification, and how you might want to be aware of those. Then what we'll talk about is the estate planning. So how do we set up wills for families who have a person with a disability that they're trying to support and create an inheritance for, and make it work with these provincial disability rules to keep the person eligible. We'll talk a little bit about choosing trustees, because in almost all of these plans, we are going to have a trustee. So part of the key process to that is picking the right person to be able to do it. We're going to have a lot of trust and confidence and faith in that person. And it's important to know what the roles are that they have to perform and what the characteristics are that you're looking for in the person to be able to do that for you. We will also talk about some other planning tools. It's not all about trusts. There are some other things that we want to be aware of, and I'll highlight for you a little bit of some of the resources that you might want to think about. So just jumping on from there, why is it that we need to talk about estate planning? So in this province, the way that we as a community have decided to support our citizens who have disability is through community supports called employment and income assistance for persons with disabilities. And so the basic rule there, or basic thrust of the program, is that if a person is over 18 and they have a disability, they may qualify for a monthly pension and other supports like medical assistance for benefits from the Ministry of Social Development and Poverty Reduction. However, there's really two elements to that eligibility. So one is the disability itself and what needs or eligibility that might create. And then the second is financial. So on the disability side, the questions relate to daily living activities, how the person's particular condition or circumstances affect their ability to do certain daily living things. And there's a questionnaire that many of you are probably aware of that gets filled out by a physician or another healthcare provider to provide that information to the ministry. And so you must meet that threshold to show that the disability restricts your daily living activities in a way that makes it harder for you as the person with a disability to independently support your financial needs. So that's the first part. Then the second part is a financial test. And that financial test is broken up into two parts itself. There's an asset test. So what assets does that person have available to them? And then there is an income test. So when it comes to the asset test, you will see that the criteria is basically having less than $100,000 of liquid assets available. And I'll point out that that is actually a relatively generous amount compared to what it used to be. When we were doing this 15 and 20 years ago, the amount was $3,000, not much more than that. And so it has increased significantly over time, but it is still limited. And so $100,000. There's a motor vehicle that's allowed to be owned as being eligible, and then also the residence can be owned to be eligible. But as soon as you had $110,000 in a bank account, you would no longer be eligible. So the key concern here is that we want to be prepared, not unprepared. If we haven't considered these rules and how they affect the estate plan that we've created, we can easily throw our person with a disability, our loved one, our son or daughter, or whomever it is, offside and no longer eligible for that assistance. And so we do need wills to make that happen because it's the will that allows you to customize how you're going to be transferring these assets and protecting them for those eligibility tests. Without a will, the province itself will impose upon your estate what it is that should happen. And there are very arbitrary rules, but the key one is, beneficiaries like a son or a daughter would be receiving their money directly without any protection around it from the eligibility rules. And so this is what we're talking about on this slide. If you have no will, then it's not your wishes that matter anymore. The province itself will set up the rules as to how that works. And just to give you a quick idea, what happens is there's a certain dollar amount set aside for a spouse, and then it is divided the rest is divided half to the spouse and half to the children. So that dollar amount is, if the children are only children of the person who's died and the surviving spouse, so it's a nuclear kind of first marriage family, it's $300,000 for the spouse, and then the rest is half to the spouse, half to the kids. If it is a relationship where there are children from other relationships, so what we would call a blended family or a second or later marriage, then it's reduced to $150,000 for the spouse, and then again, half to the spouse, half to the children. Well, if you're living in Vancouver and you own a home, it is quite easy to be well above those amounts. And so it's quite likely that a significant amount would be set aside for one of the children and would go directly to them, again, without any protections, quite possibly throwing them over the $100,000 threshold and causing them to lose the eligibility for the assistance. They may still have all of the disability criteria met in terms of their medical or physical or mental needs, but because they're over the financial test, they no longer get that assistance until they've spent themselves or done something to get themselves below that $100,000 threshold. So that's the bad news of not having a will and why we would want to do some better planning. So some of the other ramifications, as we've talked about, as I've said, you'd be over that $100,000, but the other one is for minors. So if you have minor children and you have not used the opportunity in your will to name who would be the guardian, and there's no surviving parent, it does not default to next of kin. It is actually the ministry, a government ministry of children and families that takes custody of those children. And the public guardian trustee takes custody of any assets they would have. And now the family members are left trying to recover that control and have the family have influence about how that should be dealt with. So what do we do? What's the solution to these problems? Well, the most common solution we use is creating a trust. So when we draft a will, we have the ability to say, this is what I'm setting aside for my children and my spouse, but in particular for my child who may have the disabilities and is currently receiving or will be receiving the provincial assistance. We can design it so that their inheritance is sheltered or protected in a trust. You'll often hear it referred to as a Henson trust. The technical term would be a discretionary trust. And we're going to talk a little bit about what that means. So what are the advantages of doing that? Well, it gives certainty about what's happening. It preserves the provincial benefits, that it is an effective vehicle for being able to do that planning. And the other part about it is that these trusts, even aside from creating a shelter for the benefits and preserving those benefits, these trusts are also a really effective way to help make sure that there's a decision making about how this large and significant and very important asset will be used to protect that beneficiary throughout their lifetime. So if they are affected through their disability or otherwise in their ability to make good long-term strategic decisions about how assets should be used for their benefit, the trust allows you to pick someone called a trustee, and we'll talk about how you make that selection in a minute, but it allows you to pick someone who can help make those decisions. Effectively, that person steps into your shoes and now decides how this inheritance should be used for the best benefits of the person with a disability. And so I'm going to pause for a minute and just kind of tailor this a little bit to the autism community. And so, as we know, there is a broad spectrum of autism and how one is affected by autism. And that means that the person may not always meet that medical or a disability test to be qualified for the provincial assistance. Some folks who are affected by autism are able to perform daily living activities, are able to provide and work and have an income for themselves, but still do have some challenges with certain things that they have to do in terms of decision making or social interactions. And so in those cases, this last point about the trust being there to help with decision making shows that it's not just about preserving the provincial benefits. Sometimes having that trust is also really important, and often also really important, to make sure that there is guidance there. So that when that inheritance comes down, somebody that you trust can effectively mentor the child or the loved one in how that money can be used for their benefit and moving forward. So what does the will do? Well, it gives you the control to be able to make your own decisions about all of these things. And so that includes picking what we call the executor. So the person who's going to be in charge of the estate, gathering everything up, deciding how and when to sell things and to make the distributions. You can, as we mentioned a minute ago, appoint a guardian. So if you have children that are underage, you can choose who will take over those parenting responsibilities for you. You decide how your estate will be distributed. And as I've mentioned, when it comes to working with someone who has eligibility for that assistance from the province, the PWD, Provincial Disability Assistance, or simply would benefit from someone helping them make decisions about their inheritance, you can set up trusts, and those trusts can provide that guidance. So one of the things that we have to be really clear about is that sometimes people look at this planning and look at the trusts and try to come up with what seems like a more simple solution. And so the example that I'm thinking of here is it was not uncommon quite a while back for families to look at it and say, well, I've got 3 children, one of whom has these special needs. But I don't want to go to the bother of trying to create this trust. It all seems very complicated. And so what I'm going to do is divide my estate into 2 shares among the 2 children. I'm going to leave the 1 child out, but I know the 2 children will take care of that child. And so that type of planning, particularly in British Columbia, but also in other provinces, runs into a really big problem. And that is this. We have in British Columbia a law called Wills Variation. It's under a particular statute called the Wills Estates Succession Act. And that section 60 of that act says that there is a moral and legal obligation to provide out of your estate for both your spouse and your children. And that includes your adult children. So as soon as we design a will, like that example, that does not equitably divide up the estate, there is an ability for that will to be challenged, and it can end up in court under what lawyers will refer to as a wills variation claim. And so some clients say, well, but that child will never challenge it. They either don't have the ability to think to do that challenge, that just wouldn't be part of their decision making, or they might not want to do it from there. But one of the things that we have to know is it might not always even be their decision to do that. So when a person dies and we're processing their estate and their will, and there is someone who is affected by the will, who's a child who may have a difficulty with decision making due to a disability, there is a legal obligation to send a notice, not just to that child, but also to the office, the government office called the Public Guardian and Trustee. And the Public Guardian and Trustee has the role of very, vociferously defending the rights of any person who may have difficulty making decisions for themselves. And so they will always approach it from a very self-interested point of view on behalf of that person. And they would certainly in that scenario bring a challenge to the will. So now all of a sudden your will and your estate are caught up in litigation that is being run by, whomever the lawyer is that public guardian trustee hires on behalf to make the claim to say it's not fair that the one child has been left out. So it's really not an effective strategy to use. And there are better ways to do it. And that's what we're going to talk about this morning. So you do have to ensure, because of these laws, that there is an appropriate share that has been set aside. And as I've mentioned, if you don't do that, then the will probably be challenged and in order to get a more adequate or larger share. In some cases, that challenge results in the public guardian trustee asking for even more than an equal share for that child. And as I said, it could be the person with disabilities who brings the claim, but often it's the public guardian and trustee who does it on their behalf. So the more effective way to do that would be to still create a will that divides it into 3 shares. And the share that goes to the person with the disability, we wrap that in a protective trust or a disability trust. And so the advantage there is the way that trust is designed, the assets that are in the trust, the inheritance that goes into it, is not treated as an asset of the person with disabilities. So when they apply for their assistance or report what their status is to the province, they are able to say, this is not my asset. Do not use it to count it against my eligibility. Look at my other assets and keep that total under 100,000. But the assets in the trust, even if they're more than 100,000, don't count. And the reason they don't count is the trust is designed as what we call a discretionary trust. And that means that the beneficiary doesn't have the right to demand the money. The trust is exclusively for the beneficiary usually, and can only be used for them during their lifetime in most cases. But it's up to the trustee to decide when to do that and how to do that. And because it's up to the trustee, that means it doesn't count as an asset for the beneficiary when they're trying to get their eligibility established. And so, as I've said, it's an excellent way to ensure that you maintain that eligibility for the provincial assistance, but it's also just good planning in a lot of cases, because you have someone that you pick and that you have confidence in that can help make decisions about safeguarding future needs for disability-related costs and protecting as well from vulnerabilities to others. So I haven't really talked about that element of it. The trust is often as much a shield from other people that are out there, third parties, bad actors, who might try to come and take advantage of someone who has vulnerabilities in their decision-making and see all of a sudden this inheritance as a target for them to try to extract money. And so having it in the trust, again, gives that protection, because it's not enough to go through just the person with the disability. They would also have to go through the trustee to get access, who can safeguard it. So what is a trust? So I've used this term a few different times, saying, take the inheritance for the one child and instead of giving it directly to them, put it into a trust. Well, a trust is really effectively just like a relationship with respect to property. And so one kind of simple, funny example that I've given to folks in the past is I have a son and a daughter. If I took them to the movies and we bought our popcorn and our candies and we sat down and the movie was about to start, and I had the M&Ms that I had bought for my son, but I all of a sudden had to go to the washroom. I know if I give him that package of M&Ms and leave even just for 5 minutes to go to the washroom, there's not going to be any left by the time I get back. He's just going to plow through the ball right away. And so what I do instead is I say to my daughter, here's the M&M package. Your younger brother, these are for him. You do not eat them for you. You can only give them to him, but I'll let you decide when to give them to him, and just make sure that you're making good decisions about that. And off I go. So I've just actually created a trust. So what happens is me the person who has the asset initially and sets out the rules, I'm what we call the settler. My daughter, the person who now has the asset, because I've transferred the M&Ms to her, and who can make decisions about when to give those M&Ms to my son, she is the trustee. And my son, the person who's entitled to get the M&Ms at some point when the trustee makes the decision and is the only person who can get the M&Ms, is the beneficiary. And so that's just a really kind of simplistic explanation of how some of those relationships work. The settler, me, my daughter, the trustee, and my son being the beneficiary, and the subject matter being the M&Ms. And so what we do in your will is we just take that, and now instead of it being the M&Ms, this is the inheritance. So this very large proportionately compared to M&Ms amount that's going to be set aside has all these same ideas. As the settler, you, when you make your will give some instructions to a person that you pick, your trustee, telling them this is how I want you to hold and use this inheritance for my son or daughter who is the beneficiary. So there are many different types of trusts to be aware of. And so let's talk a little bit about that. So the first is inter vivos or living trusts. So what I described to you about the M&Ms, that would be what we would call an inter vivos or living trust, because I'm alive as the settler when I create this trust and set it up. A testamentary trust is a bit different. That's the other scenario that I described is your will. So the inheritance that you give to the beneficiary is something that you're going to do when you pass away and you no longer need or want to have control over those assets. You're under your will, giving instructions about how to transfer it over. And we use that term testamentary. So testamentary just means taking effect on death. So that's the difference between a living trust and a testamentary trust. And most of our clients are doing testamentary trusts because we do have assets. We keep them to use for ourselves during our lifetime, but we want to pass them along afterwards. A smaller proportion of our clients use inter vivos or living trusts because that really depends on having some free available value or capital that we can transfer over into the trust for our loved ones that we won't need during our lifetime. So it's very situational specific. We see those types of living trusts for things like accident settlements or unexpected money that comes in from a relative, or if parents are going to help, for example, with a house or other things like that, and do have available capital that they can commit and don't need to recover back. So the emphasis is about how the trust is created. And it also affects how the trust is taxed in terms of its income. I'm not going to spend a lot of time today talking about the taxes, just for you to know, though, that it is a really important consideration when these trusts are being set up, that someone also is thinking about how they're going to end up reporting tax and paying tax. So in terms of the policy for the ministry, there are actually two types of trusts that they will say are exempt from the asset test. The one is the most common one that I've been talking about, which is the discretionary trust. And that's the one that says it's entirely up to the trustee to decide how much money goes to the beneficiary. The beneficiary has no entitlement to demand any of that money. And so any amount can be put into a discretionary trust and be avoiding those eligibility asset tests. The other type of trust is less often used. It's called a non-discretionary trust. And this is one where the beneficiary does have an entitlement to access those assets. So the trust is designed a little bit differently. It could be because maybe the beneficiary is the trustee and has the control that way, or maybe there could just be some rights that are written into the trust agreement that gives them that. But what's important to know is that non-discretionary trust, it has a capped limit. The most that can go into it during a person's lifetime is $200,000. And so we really use that in situation-specific examples. So it would be maybe there's a a modest inheritance of $160,000 from a grandparent that we didn't expect. It's gone down to the beneficiary. And so we have them create a non-discretionary trust so that they can keep some autonomy and control over it and make themselves eligible, because of course 160 would put them over the 100,000. But if they put it into this non-discretionary trust, it's less than 200, so they can do that. It gets them eligible again. So the non-discretionary trusts, just to recap what we've talked about. So there is the control issue. If the value is under $200,000, it would be fine and exempt. There is an ability, I should mention, the third point on this slide, to exceed the $200,000, but it does require consent from the government, from the minister. And so we would have to talk a little bit more about that. In most cases, we're doing a discretionary trust. That's usually the preferred vehicle. But if we do have a beneficiary or a person with disability who is able to make decisions, is able to manage their affairs, and does want to have some more control over how the trust operates, we can at least put it on the table to talk about the non-discretionary trust and how that might work. As I said, though, it's the discretionary trust that is the one that you are going to more often see and more often use. And so just to talk a bit about the discretionary trust, you'll hear them referred to as Henson trusts. Henson is the name of a family out in Ontario back in the 80s who had set up one of these trusts. The Ontario government challenged it, and they went through the courts, and the courts eventually confirmed, no, it's okay. You can have these types of trusts, and they do work to preserve eligibility. So that's where the term Henson comes from. But as you'll see on the slide, and as I've said a couple of times now, that means it's absolutely discretionary. The beneficiary has no entitlement, no legal right to go and demand any money. We've picked a trustee who is different from the beneficiary, and we've given that trustee the full authority to decide, what will be paid down and when. And if it is done that way, there are no limits on the amount of money that can be put in there. And it does allow them to retain their eligibility for the assistance to be able to do that. So there are some tricks that you do have to watch for in terms of reviewing the trusts. So the trust it's primarily for the person with a disability, but we do have to think about the ultimate beneficiary. We have to think about who would be the beneficiary when that person passes away. And it's very important to have that in the trust because there are some special legal rules that say if you don't, then the person who is the beneficiary can have a legal right to demand the trust. And we don't want that to be the case, because that would make it a non-discretionary trust and mean that it's limited to the 200,000. We want it to stay as a discretionary trust. So it's important that we not only name the beneficiary for their lifetime, but we also name who will be the beneficiary after they pass away. The other thing that we want to do is, under the basic rules of trust law, there's a principle that says when you've got somebody that has a lifetime interest and somebody who's going to get what's left over afterwards, you're required to balance those things out. You always have to think about, what am I going to make sure is left over for these other people? It's called the even hand rule. But we don't want that usually in these trusts. Usually in these trusts, we've set aside the money because the main purpose is to fully take care of that person, the person with a disability who has the life interest in it. And so we have to put terms in the trust to say to the trustee, you don't have to think about these people. Your job is to take care of this person. If there's happens to be something left over, fine, but really the primary purpose is the person with a disability. The other part is the control over the trust. And what in legal terms we call a collapsible discretionary trust. So you have to be really careful to make sure that those legal rules don't kick in, because again, if it can be collapsed, that creates a legal entitlement in the beneficiary, and it undoes what we were trying to do in terms of making it a discretionary trust. And so you don't want to have the trust giving any specific legal rights. You want to put that responsibility with the trustee, who is instructed to be generous and to certainly take care of that beneficiary, but it's still their decision to make. A quick example of that is it's not uncommon for clients to say to us, okay, great, we've got this trust, and what I want to do is add in a term that says, make sure that at least $400 a month goes to my child, so that I know that they've at least got some money. Well, if we did that, if we put that clause in the trust that says, by the way, you must give them at least $400 every month, we've just created an entitlement. And so it's no longer a discretionary trust. And the effect of that would be the $400 a month that they get from the trust would just be immediately deducted from their entitlement check the next month. So if they were getting $1,300, they would be immediately reduced to $900 because of that $400. All you've done is replaced what they would have got from the government with money from the trust, which really could be better used in other ways. So again, it's careful planning and knowledge required to set the terms of the trust to make sure it works the way that you want it to work. So I've talked a lot about the asset test and keeping under the $100,000, using the trust to be able to do that. But there is also, I mentioned at the beginning, an income test. And so the way the income test works is it says to the person with a disability, every month you have to file a report and tell us, the government, if you've received any cash or value amounts during that month. And if you have received what we consider to be unearned income, you will be deducted from your next month on that. So that $400 that I just talked about would have to be reported as unearned income, and it would get deducted from the next check each time that that goes through. And so there is an exception. So there is earned income. So earned income means money that is paid to you for services that you've provided. You can think of it like a T4 for work, for wages. And there is up to $15,000 a year that can be exempted for that. But otherwise, pretty much everything else is unearned income. So if we had a trust and we were stuck under just those rules, the problem would be we've exempted the asset test by putting this inheritance into the trust, but every time we want to pay money out, we would have a problem because we would be having to reporting it as unearned income. Well, we can avoid that problem because of what's on this slide. So this slide talks about disability related costs, and this is key. It says, and this is taken out of the law, the rules, it says that as long as the amount that's being distributed from the trust is being used for a disability related expense, it is exempt. It will not disqualify for the income test. And there are a number of criteria that can qualify as a disability related cost. And so on the slide, you'll see caregiver services, education or training, home renovations necessary because of the disability, maintenance repairs, medical aids. Those are all unlimited amounts as long as they're done for those purposes. And now we also have an unlimited amount for promoting the person's independence. And this is actually a very broad category, and it's been interpreted quite broadly. And this is the one that, if we fit into those above categories, great. If we don't, then we just need to start thinking about, well, is the amount that I'm paying out being used to promote the person's independence? If yes, then they can claim it as a disability related cost, and it will be exempt. So what are some examples of that? Transportation. So being able to move around in your community would be something that would make sense to do that. Any sort of cultural activities or sporting activities would be an example of that. Going on trips to spend time with families or to expand your world experience would be a good example of that. Cell phones to be able to stay in communication and allow you to be more independent in the community, so you can always have an emergency call back if you needed to. So there's just a wide open range there, but you always have to make sure that the expense does relate back to and can be justified as promoting independence. Again, you can't just pay $400 a month without thinking about what it's going to be for. you need to make sure that you can say that $400 is being used for promoting independence. But it creates a wonderful opportunity to supplement the resources that are available to that person every month, and help them live at a higher standard of living than they might otherwise be able to afford to on the limited amount that comes from the province. So we did talk a little bit about earned and unearned income. And so these are just some of the rules that you want to be aware of when you have a trust and you're working with the ministry to keep things moving along effectively. And so earned versus unearned, just to recap that, you could assume that everything is unearned income unless it is wages that you are paid for performing a service. And as I mentioned, up to $15,000 a year is currently exempt. After that, there's some effects. And then disability related costs are exempt from those tests. So what you want to do is look at the trust and do kind of a budget for the person and figure out, where are they spending their money and how can we use the trust's money to help enhance what they're doing and keep them eligible for all the benefits and not get offside. So what do we submit to the ministry? That's Social Development and Poverty Reduction, SDPR, kind of the short form. So when the trust initially takes effect, you have to submit the trust or the will that creates it. You have to tell them what the assets are that are in it. They will review it and make sure that, yes, they agree that it is a discretionary trust. And then after that, there is the requirement of the monthly reporting. And so you would keep track that way as well. And then finally, although you don't have to submit it, it's very important to keep records of what you're doing with the trust, because the ministry can come back and request an audit of what the trust's activity has been. And you want to be able to show that. So you want to be able to say, yep, 2 years ago in January, when I paid out $100, that was for the cell phone. Because if you can't match it up to a disability related cost, there's a risk that they could say that it was offside. So the asset that are in the trust, it can be really anything. So whatever your inheritance is down to your loved one, that can be put into the trust. So it could in fact be a home. Now there's a whole other session that we could do for multiple hours about owning residences and homes. And so I can't really go into much detail about that, but just so that you know, that certainly is a possibility. The inheritance could be used to acquire a house, or it could be a house that was already owned, and it could be sheltered within the trust. Other things that can go in there are life insurance policies, RSPs, RIFs, and other designations. You do have to be careful about how you do that, but it is possible to get that value into those as well. I'm actually just going to go back and say one comment about the RSPs and the RIFs that will be really important for you to know. If you have a loved one who qualifies for the disability tax credit, that's a federal thing. And again, based on your ability to do daily living activities and medical tests, then there are opportunities for you to transfer the funds that are in the RSPs or the RIFs upon your passing to them and defer the tax, and in some cases avoid the tax that you would have otherwise have to pay. So when we put money into an RSP, we get tax credits, it grows tax-free, but when we pull it out, we pay tax. Upon my death, I can transfer it to my spouse without paying tax. She won't pay tax until she pulls it out. But as spouses, when the last spouse passes and it goes to the children that are adults, it's usually fully taxed. So if I have $200,000 in an RSP and I'm the last spouse and I'm giving it to my adult kids, we could expect that to be $200,000 of income and pay, in the range of $60,000 to $80,000 of tax. There is an exception. If that RSP goes to a child that I have who has the disability tax credit and otherwise meets certain criteria, we can roll it over. And so just like a spouse, there's no tax until they use it. But even better, when they use it, it's taxed at their rates, not my rates, not my estate's rates. And so if they've got limited income, there's $15,000 to $20,000 a year that they can pull out depending on their circumstances. That's almost tax-free. And so we can take an RSP product that would have been an $80,000 tax bill to your state and almost get all of that $80,000 back to be used for your family. So again, it's really important to be thinking about these issues when we're designing the estate plan for you. So what are some of the other things that we consider when we're developing the trusts? So the first is the trust the best way to do it? It is the most common way, but there are other tools, and we'll see in a minute. Something like a registered disability savings plan, an RDSP, is a viable option. And it does have exemption room up to $200,000, and it will be an exempt asset. It doesn't affect the disability. And so there are some other ways to do things. The trust isn't the be all and end all, but it's definitely a tool that you want to consider. And it is the most common one that we do, but there are other ones to look at. Other things to think about are just the personal circumstances. So capacity, what's their decision-making ability? Should they be involved as a co-trustee in the trust? And also, as I mentioned before, even if they're not a person who gets disability assistance, might they still benefit from having a trust because someone will be able to mentor them and help them make decisions. Other factors are, of course, if they're married or single, or if they have children of their own that we'll want to be able to make some provisions for as well. The life expectancy of the beneficiary is important. We have to think about, in a minute, we're going to talk about who would be the trustee. So how long will we need to have that person in effect as the trustee? Also, how will we use the money in the trust? Because if there is a limited life expectancy, it doesn't make sense to, try to preserve all the capital for a time when they may have passed away. We might accelerate how we're using it. What their existing assets are. So if someone receives $100,000 inheritance, that may not be a problem if they don't have any other assets. But if they already have $90,000 of assets, well, now we know we need to put something in place. And then the choice of trustees, which we're going to talk about in a little bit more detail here. So issues in choosing a trustee. So as we mentioned on the last slide, what's the age of the beneficiary and how long do we think that this trust will need to last? So in some ways, it would be unusual for a client to pick their parent to be the trustee of a trust for their child, because just that time expectancy alone. There is a special rule that you may have heard about and would want to be aware of, that trusts every 21 years are treated as if they've sold their assets. They still own them and it's still part of the trust. It's just for tax purposes, you're treated as if you've sold it. In most cases with these types of discretionary trusts, we don't have to worry about that. There's ways to plan around it, but it is something that we still need to be aware of. So the age of the trustee, as I said, picking someone who is your age or older for a trust for the generation below you could be a bit of a challenge. And so you might need to think about backups. How many trustees should you have? Is it one trustee, or is it better to have multiple trustees so you create some balance in the decision making? But in any event, always having a backup to whatever trustee you've picked. And the other part is this is not usually just a 30-second phone call to someone to say, hey, will you be my trustee? Yes, great, okay, good. And you put their name on. It's really important that you have some discussions with them, make sure that they're aware of what it is that they will be doing, and also being aware of what the circumstances are and what's life like for your child or the person with the disabilities that's going to be the beneficiary of the trust, and what are the important things that the trustee will need to know to make sure that they have the best life that they can. There's a quote that I've heard that I think really sums it up. It says, every time someone dies, a library burns. We all have very important information up here in our noggins. It makes a big difference in other people's lives, and particularly for the life of someone who themselves can't communicate that information to somebody else. And so if we can capture that information and pass it along, as much as the legal planning is important, that can be just as important in the quality of life. And so that's a good resource to think about and do for your trustee. They would thank you greatly for having that information. As a quick example, we had one client who was taking care of their sister, and in her apartment, they had put stick-it notes on all the cabinets, and they were color-coded so that their sister would know what was in those cabinets and what she was supposed to do about them. And it was a code that they developed over time, and it just worked for her. That was how she processed information. So if you passed away or that client passed away and someone came in to take care of the house, the first thing they decide to do is clean up the house. There's all these stick-it notes all over the place. They will have entirely stripped out that coping and mechanism that the sister was relying upon, and she wouldn't have been able to tell anybody. So it was really important for them to pass that along and make sure people understand what was actually happening there. So other issues, do you want to be able to change the trustees, or do you want someone else to be able to do that? Does the trustee have knowledge about these rules? As you can tell, there's some complexity to how the rules work. They don't have to have perfect knowledge, but they should have some awareness. We don't want them, going off and doing something that immediately creates problems. Where do they live? It's of course nice to have someone that is geographically close to you and your beneficiary, but it's not strictly necessary. However, if they're outside of Canada, then there are some big problems. And that's usually not the best trustee, at least not without a co-trustee. The size and complexity of the trust and what the assets are that are going to go into it. So if you're picking a trustee, do they have the same skills that you have to manage those assets? And then avoiding conflict. So people often will start with thinking about family members or friends, but we are more and more seeing clients move towards neutral corporate or professional trustees, just because of the expertise, the heavy burden in doing things, but also avoiding any sort of difficulties. So it's not unusual for our clients to first think of, if a family of 3 and one person has a disability, it's not unusual for our clients to say, well, the other 2, they should be the trustees, they should be the executors. And that's very common. They're the people that you trust, they're the people that know, but there's also a potential conflict there because, we have to remember they are siblings. They have an entire sibling dynamic that goes on, and having big brother or big sister be my trustee may create problems that wouldn't exist if it was a neutral trustee. I describe it to the clients this way. If Thanksgiving dinner is next week and we're all supposed to be getting together for Thanksgiving dinner, but this week you had to tell the beneficiary, no, you can't go and buy a $70,000 vehicle, even though you think you desperately need it, that dinner is going to be awkward because you've had to disappoint them from something that they really want, even though it's probably the right thing to do. And so how much better would it be if that burden to say no was on somebody else, a neutral professional trustee, and you could have the dinner and you could listen to the complaints about not getting the $70,000 vehicle and not have to take on any of that. Just nod your head and say, yeah, I can understand you're really frustrated. Well, inside you can say, I'm really glad that that trustee made that decision. So it's those dynamics. We don't want to jeopardize the sibling relationships for the purpose of creating the trust. So I did mention to you that we would talk about other planning tools. And so, as I said, a trust isn't the only way to do it. If the amounts are under $100,000 or can be spent in reasonable ways to get below the $100,000, that's often a simpler solution. You can put the money into a vehicle or a residence. However, having the person with a disability own a residence may create vulnerabilities and challenges, so you have to be careful about that. Gifting is an option. The RDSP we spoke about, having that $200,000 amount available. You do have to be careful. I would encourage you not to use the whole $200,000 room because you want to keep room to be able to put deposits in the future to claim the grants and bonds in each future year. So it does require a little bit of strategic thinking about how you would do that. And then the RSP RIF rollover that I mentioned. So this idea that if you have RSPs or RIFs or pension funds that would otherwise end up being taxed when you and your spouse pass away, we can design an estate plan that can often transfer those assets to be part of the inheritance for your child with a disability in a way that avoids that tax and then sometimes eliminates it because we can use their tax rates. So the good planning is often a combination of these. We don't walk into it saying, you need a trust, that's what you need, and away you go. We walk into it saying, what's your goals? What is it that you want to do? What do you want life to look like? What are the assets you have available to support that financially? And then we say, okay, what's the best way? What are the best tools and strategies to get you to that point and try to create it? And almost all of our plans are blends of some of these things when we're doing it. So the other part is, who's going to do this for you? Who's going to help you put this all in place? Because I understand, there's complexity here. This is not something that, you deal with on a day-to-day basis. It's something that I deal with on a day-to-day basis, and it's still complex. The rules are always changing and being done. So definitely you want to have, in my opinion, a lawyer do this planning for you. But I think it is important that you also make sure that it's a lawyer who understands this area. Any lawyer in the province can draft a will. There's no restrictions on that. But you want to make sure it's someone who not only has experience with wills, but also has experience working with the disability community, so that you can make sure you're taking advantage of the rollovers like the RIF and the RSP, making sure that you're not creating a trust or a plan that inadvertently disqualifies the person from eligibility or triggers a possible challenge by the public guardian and trustee. So not all lawyers have that understanding. And so you can ask some simple questions to be able to kind of determine whether it's the right fit for you. And so that could be asking, how many families has the person or the lawyer assisted with this? How much of a part of their practice is doing that? And also maybe ask them to explain to you how they see things like RSPs and RDSPs fitting into the plan. They should be able to provide you some of the basic information that we've talked about today, so that you can feel comfortable that they're thinking about all of the options for you. And as I said, sometimes it seems like a simple thing, but it could end up being a big lost opportunity. Even just the RSP rollover, as you can see, can make a big financial difference. And so I'll just wrap ourselves up here for the first hour with these kind of final words of advice. So do what you're doing right now. Gather the necessary information. Go out there, talk to people, go to webinars, read the material that's available. Make sure you're talking about BC stuff and not other provinces, because the rules are different in other provinces, and get informed about what's happening. Then consider future events. What are those possibilities down the road, both for you and for your loved one or your child? What will home look like for them when you're not in the picture to provide what you provide? Then the trustee. So think carefully about who should be the trustee. That's part of our job as lawyers, by the way. So it's not just drafting your will, it's also helping you go through the process of evaluating what your options are and what the strengths and weaknesses are of those options. But of course, once you've picked a trustee, making sure that they are willing and able to be able to do that. As I've suggested, have a lawyer who has some experience in the area help you guide through this process, and then ask questions. Always don't feel uncomfortable asking a person to explain something that might not seem clear to you. The true mark of someone who is an expert and has knowledge in the area is their ability to explain something in plain language for you. These are complex ideas, but the person you're working with should be able to help you feel at least comfortable that you have enough understanding to make a decision about what you want to do. So we are 11:29 by my clock. And so hopefully that's given you what our objective was, which is some kind of broad information. I imagine for some of you, this is repeating things that you've heard before. But what I'd like to do now is maybe just stop my talking and turn it over to Stella and to you with your questions, and see what I can do in terms of providing some more clarification.
Okay. Thank you so much, Geoffrey. So for the next half an hour, I gather at least 20 questions, but some of these questions are kind of similar. Maybe I can try to group them together. And if after Geoffrey answered all these questions, and if we still have time, maybe you can ask more. Okay, so the first question is about the liquid assets. So two people ask, Is are RESP and TFSA kind of like are they exempt, or they are counted as the liquid assets for the $100,000?
Right. Yeah, it's a good question. So for sure, the RDSP does not count as an asset. So the RDSP is specifically exempted from the rules. And so you do not have to count that when you're adding up to figure out, are you under the $100,000 threshold? So that's the good news. Also on the RDSP, when it actually kicks in eventually and starts providing its income, its monthly income, that is also exempt. So if the person happens to be still getting PWD benefits at that time, that income does not count as unearned income. It's exempt from the test. So the RDSPs in that context are very, very good. You just have to keep in mind what the purpose of the RDSP is. It's really meant to be a long-term pension fund. And what I mean by that is there are rules that make it very difficult once you've put money into the RDSP to just try to pull it out. Because if you're taking advantage of the government grants and bonds, the key rule is that if you try to take money out within 10 years of having received one of those government grants or bonds, then it will be clawed back. And so it's quite costly to try to take the money out early. You have to make sure you're thinking in the long term. So if you are saving up to buy a car or to buy a house or an assistive device or something like that, the RDSP is not the spot where you would put the money because it's going to be tied up. Now, having said that, it's a fantastic way to build money and wealth. There's no other investment that I know of where you put in $1 and the government effectively matches you with $3 immediately on doing that return. So they're definitely a tool that you should all be thinking about to the extent that your loved one qualifies for it. Just make sure it fits into the context of what you're doing. The other part of that question, Estella, was about the RESPs. And in most cases, the RESPs are going to be owned by the parents and not an asset of the person with the disability. So in, I think, probably 95% of the cases, that will be the status. And even though they've been named as a beneficiary under the RESP, it is not an asset of theirs. And by the way, there are some new rules about RESPs that will allow some rollover of the RESP into the RDSP based on it not being able to use for any other purpose. So it is kind of hard to get to the rollover point, but that is an option. So if you had created an RESP and it turns out that the child for whom you created it is probably not going to be able to use it for the intended purposes of post-secondary, that doesn't mean you've got a problem and have to cash it in and pay penalties. There are certain circumstances under which you would be able to roll it over into an RDSP for them. And so be aware of that when you're looking at it. Yeah.
Okay. What about TFSA?
So TFSA is a really good question. So on its face, there is no specific exemption for a TFSA. So if you have a TFSA, it will likely be considered to be a liquid asset. Now, having said that, some TFSAs, the way they're structured, are actually technically trusts. So if you go back and look at the document that the bank or the financial institution has that allows you to put money in and get money back out, it's actually designed as a trust, technically, a commercial trust. And so we have had some success going to the ministry and showing them that document and saying, well, in fact, this isn't like a bank account. This is actually a trust. It's a non-discretionary trust, so it would still be limited by the $200,000 threshold. But if it is a non-discretionary trust, that means $0 of it count against your $100,000 exemption. So it's a technical argument to make, and it does require you going back to the institution to verify, how they actually hold the accounts. But we have done that. So my words of advice are, unless you've gone through that process and got confirmation that it is a trust and non-discretionary, you should probably be careful because it might be treated as a liquid asset. But remember, you can go up to 100,000.
So the follow-up question. So that $200,000, does it include the RDSP? RDSP is $200,000.
So so the RDSP, the way it works is the most you can put in is $200,000 over the person's lifetime. It can grow, it can be worth more than 200, but the most you can put in is 200,000. But it is entirely separate for eligibility purposes. So you could have an RDSP with $200,000. You could have $100,000 of your own money. You could have a non-discretionary trust with $200,000. You could have a house. You could also have a discretionary trust with as much money in it as you want. Under that whole scenario, that individual would still be exempt. So they are kind of exclusive categories of exemptions.
Wow. Thank you so much for the answer. So the next question is from Brenda. You talk about her own children, but I think it also applies to some people. So basically, she said that like her autistic children are 5 and 3, very young. I mean, they want to write a will for them, but they are too young to decide if they could manage themselves in the adulthood. So can she use an online will program to make a normal will, and later to see when they're older, and see if they need the special will, the discretionary trust, the Hanson trust?
Yeah, so it's a really good question, Stella, because we just don't know how things are going to go. And so it's really a question of what risks you're willing to take on. What I mean by that is if you do a will that's just a basic will and provides everything going immediately to them at age 19, if something were to happen to you while that will is in place, there's no ability to change the will. Of course, that's the will that's there. And so if it does turn out that, so say something happens in the next 5 years, that's the will that will be there when they turn 19, and they will get the funds outright. There won't be the trust provisions. So the risk that you're taking is that, between now and I guess 16 years from now, if something happened to you, you are kind of stuck with that will that doesn't have the trusts in it. The flip side is if you go and spend the money now to create a will that has the trusts in it, the risk is that you're spending money that maybe you didn't have to. Maybe it turns out that when they're 19, they don't need those provisions, and you've spent a bit more money than you needed to, even though it gave you the protection. So you would have to kind of weigh which of those risks you're comfortable with. I don't think I would say that it's wrong either way. It's just that it is creating a bit of a risk there. And by the way, no matter what you set up, you can always change it. And so one way to mitigate that risk is just every couple of years, just kind of reevaluate and think about, okay, do I know enough now to make a decision one way or the other?
Okay. Thank you. So a follow-up question, you're talking about the cost, right? Spending money. So what is the cost to set up a trust for a child with disability, and also is it tax deductible? And then the other question is like, how expensive is the corporate trustee, setting up corporate trustee?
Sure. So cost of the trust, tax deductible, and corporate trustee. So in terms of the cost of the trust, it really depends on the circumstances and where it's being set up. So setting up a trust right now for someone immediately, taking effect immediately and putting money into it can actually be a pretty expensive process, somewhere between $5,500 and $7,500, because there's a lot that needs to be done to get that done and get it qualified. When we do it under your will, which is probably what most folks on the call will end up doing, you've got the cost of your basic will. And so a basic will is typically about $800. Maybe you would add another $400 if it's for a couple, so about $1,200. That would not have any trust provisions in it. When we add the trust provisions, what we're basically doing is taking all that trust and kind of stuffing it inside your will to make sure it's there to be created upon the death of both of you. But it's not going to be as expensive as when we have to do the full trust. Now, it usually typically adds about $2,500 to the cost of doing the will. And so that's typically kind of, I think, what you would see. The other thing that I should mention, just to be complete in my answer, is that it's also important to think about you and decision making for you. So if you became incapable, do you have a power of attorney that allows someone to financially make decisions for you? Because one thing that's really important for everybody to know, it does not automatically default to anyone. So if you have a spouse and you're thinking, you know, if I become incapable, my spouse is going to be able to manage things for me, that is not the case. You must have a power of attorney to be able to do that. So you might also want to think about those things while you're getting everything together. So the second question was tax deductibility. Unfortunately, there is no tax deductibility on those. It's personal planning. And so the Tax Act does not do that. I think it would be a great way to encourage people to do the planning, but it just isn't there. When the trust takes effect, and there are fees for the trustee, which we'll talk about in a minute, some of that fee can be tax deductible against the income that the trust has earned, but the cost to set up the trust in the first place is not, unfortunately, tax deductible. So the third part of that question was, you know, what are typical corporate trustee fees? So the first thing to do is provide a bit of context, and that is any trustee that you pick, whether it's a family member or a friend or a company or a lawyer or some other professional, are all governed under the Trustee Act of British Columbia, which says that the ceiling for fees in that first year of the estate is about 5%. And after the first year, if there's an ongoing trust, the fees, there's a formula, but it's basically a little bit less than 1% is the ceiling. So my advice is, no matter who you're picking, whether it's a family member or a friend or a company or otherwise, there should be a fee. One of the things that often gets difficult about estates is a friend or a family member will try to do it without being paid for doing it. And so they're doing it kind of off the side of their desk. And that's where problems happen, because they're not able to be as diligent or attentive or get as well informed as they need to be. And so my view is you should be paying that person so that they can afford to take time away from work or other things to give it the full attention that it needs. And so at the end, the fees really aren't different than what would be charged. Now, in most cases, that maximum of 5% is too large. What you will typically see is on the first $1 million of estate value, somewhere between 3.5% and 4% is typical. As your estate gets over $1 million, on the next million, typically you're seeing about 2 to 3%. After 2 million, it's usually 2%, and eventually, you know, kind of drops down through that process. So the fees are kind of gauged based on what your assets are. And every trust company has kind of a different schedule, but they're mostly similar in that structure. The other part is the ongoing fee. So that's the one-time fee on death, and it's only payable on death. You don't pay that during your lifetime. It's paid by your estate once the assets are gathered up. If you do have an ongoing trust, which these disability trusts would be, then each year after the first year, it's typically somewhere between 0.5 and 0.8% that's charged per year. Now, a portion of that is tax deductible to whatever income the trust has earned. So hopefully that's not too complicated of an explanation, but that's kind of how it works.
Okay, thank you so much, Geoffrey. So a follow-up question: when you talk about percentage, it is the percentage charge of the whole amount that the trust is there, right? The whole amount of trust.
That's right. So what you would do is you'll have your house, you'll have your vehicles, your bank accounts, your investment accounts, whatever goes into the estate, the percentage is charged on that. And then when the estate is liquidated and an amount is put into the trust, the percentage is charged on what's in that trust for the ongoing amounts.
Okay. Okay, thank you. So I think that also answer some other questions, like Peggy asked about the management of trust when the parents are not capable to manage. What's going to happen? So I guess the power of attorney is the answer, right? So you just talked about that.
So the power of attorney will help manage the parents' personal affairs, but it's really important that the power of attorney won't actually apply to the trusteeship. It's the trust document itself. And so that's why it's really important in every trust to have a backup named. So who's the backup trustee if the trustee can't act? One thing you can also do is give the trustee the power to pick who that would be. But it's really important to have a mechanism so there's always somebody ready to step in line.
Okay, that's great. So the other question is about the trustee. Just let me see. I'm kind of lost now. Okay, so let's ask this question first. So there's a parent that asks, are you saying you can set a trust and trustee for a non-minor daughter, like non-minor child who is disabled, but does not meet the official standards of disability? So some people have autism. They don't, they are not classified as disabled, but they cannot manage.
And that's exactly right. And we do that quite frequently. So whenever we're dealing with any family and we're talking about the inheritances and who's going to be receiving it, we talk about what's their skill set, what's their experience, what's their abilities, and being able to make good decisions about this inheritance that really is life-changing. For a lot of people, that inheritance is the difference between, a good, comfortable retirement and not. And so it's really important that good decisions are made. And if we've got concerns about that particular beneficiary's ability, whether there's a formal designation or eligibility for assistance or not, it's important to think about having someone there to be able to act as a mentor or a second decision maker to ensure that there's good decisions. And we often use trusts to do that.
Okay, thank you. So another question is like how to choose the trustees, because some parents, some people here ask, they don't have families here. They don't, it's very hard for them. So what are the options to choose trustees?
Yeah, that's a really good question. So there's really kind of so there's family and friends, but outside of that, because either they're not available, not appropriate, or just don't have the time. I mean, one of the challenging things is, that family member or friend who seems like they're perfect because they've got everything together and they're doing all things and they're really successful, might actually end up being a bad choice because they're too successful. They're super busy and they don't have time to do it. So a lot of clients, for those reasons, and because of some of the complexities we've talked about with the rules and the taxes, are more and more frequently thinking about professional trustees. And so there's really kind of three categories of professional trustees. There are kind of bank trust companies. So the big five banks all have trust companies that are part of their structure. There are independent trust companies that do nothing other than be trustees. They don't do investments or anything else. They're just focused on being your trustee. And then there are individual professionals. So mostly that's lawyers, but sometimes accountants as well. And so among those three categories are typically the, kind of the neutral professional trustees that we would look at. The fee structures are fairly similar among them. Some that are at kind of a higher end than others, but they're not, overly different. It's more a question of style and how they would approach things and who you would be most comfortable with. And so what we often do for clients is if we see that that's probably something that they should explore, we will set up interviews for them to go and talk to representatives from the various options. And we give them questions that they can use. They don't have to use all the questions, but it's just guidelines so that they can start that conversation and gather information and just see who they're comfortable with.
Okay, thank you so much. So the next question from Tina is that, is there a limitation of time on a will variation? That means like, like a time limitation to file.
Yes.
The will variation.
Yeah, there is actually. That's a good question. So if a person is going to challenge a will on the basis that it hasn't provided them an adequate share and they are a spouse or a child and they're going to use that Section 60 of the Wills, Estates and Succession Act, The rule is that from the date of probate, so not the date of death, but the date that the will has been submitted to the court, reviewed by the court, and then the court issues a document saying, yes, this is the official will called the grant of probate. From that date, 180 days is the time period within which a claim would have to be made.
Okay. Yeah, thanks. So the next question is like, how long can the trust last?
Oh, good question. So technically, a trust can last up to 80 years in British Columbia. There's a rule that says you're not supposed to go past 80 years. And so really it comes down to a cost benefit analysis of how long does it make sense to keep the trust going. I have had a trust that went 76 years. Obviously was not one that I drafted, but it was a client whose father passed away in the mid-century and continued on for her and continued on for her kids. She was quite young at the time. And eventually we wound it up because it was passing among her children and it was just getting divided up so much that it wasn't worth keeping it going. But most trusts will be typically for a person's lifetime and then maybe a little bit afterwards to divide up. There is, as I mentioned during the slide presentation, a tax rule that says every 21 years you will be treated as if you've sold what's in the trust and you'll have to pay taxes as if you've sold it. But that does not stop you from keeping the trust going as long as you have a plan for how you deal with those taxes. So it can last quite long. These disability trusts are often intended to be lifetime trusts and can last decades, if not longer.
Yeah, thank you. So the next question is, can you have a mix of discretionary and non-discretionary trust, like the money becomes fully open to the child at a certain age?
So, so what you have to be careful about is as soon as you add non-discretionary provisions into a discretionary trust, it's just not a discretionary trust anymore. So if you want to keep that eligibility, you need to really make sure it's a purely discretionary trust. If someone had a concern about wanting to make sure that money was legally required to be transferred at a particular point, we would probably consider, doing two different trusts, one that was fully discretionary and one that paid out the money at a particular point in time. But that would probably require a further discussion about, why is it that we want it to be mandatory? I would suggest you might be better off picking a trustee that you have a lot of confidence and faith in and simply giving them the guideline to say, at this particular point in time, if things are going the way I expect them to do, as your discretion, I'd like you to pay this amount out to the beneficiary. And then that way you've got the plan, you've got the mechanism to do it, but you've got somebody who can kind of adjust for the circumstances to make sure it still works. So an example would be, what if, it was paid out when they reach age 30, but it turns out that, their marriage that was at age 28 is about to go through a divorce at age 30. You probably don't want the money paid out. And so your trustee, if you gave them discretion, would be able to make that decision for you.
Okay, thank you. So there are questions about like how to make sure that the trustee is accountable. For example, is there any way to check in to see that if how the trustee manage the money is fair?
Yeah, that's a really good point. So trustees are usually given quite broad powers, but at the same time, they are very much accountable for what they do. And so they have to be transparent about what they do, and they have to provide reports. And those reports get approved by the beneficiaries. Now, if the beneficiaries are not in a position to have the full decision-making ability to really review that and vet it, the court will do that on behalf of the beneficiaries. But it's also possible for you to set up your own private mechanism for doing that. So it's not unusual for us to draft a trust that says, by the way, Royal Trust, you're the trustee, but my brother will have the right to check and find out what you're doing. So he can ask for reports, he can ask for statements, and when you get your accounts approved, you have to make sure he gets a copy. to take a look at it. So we can build kind of an advocate or monitor into the trust, so that you know that someone that you have confidence in, who might not be able to take on the burden of managing the trust and making all the decisions, will at least have access to the information to ensure that accountability is there.
Mhm. Thank you. So the question about the family home being gifted to the disabled child, like can the family do that? And also, can we put the child on a house title to make it easier? Can we do that?
Yeah, so the short answer is yes, it can be done, but it probably in most cases raises way more complications than is worth the benefit. So a house, as long as the person with a disability is living in it as their principal residence, is an exempt asset. So it will not throw them offside for the eligibility rules. However, if the person with a disability has decision-making challenges, there's a question about whether they have the capacity to really own that asset and deal with it on their own. And so we have been consulted by people who kind of thought that was a good idea and did it and didn't realize what they had done. Because what happened was they added their child's name onto the title, but then for some reason they needed to sell or get a mortgage later. And they realized that that meant that they needed not only their signature now, but they needed their child's signature. And that meant that a notary or a lawyer had to be satisfied that their child fully understood what was happening and all the consequences of what was happening. And because they didn't, this particular situation, they had some decision-making challenges and they didn't have full capacity. That meant they had to go and get court approval to be able to sell the property, because only the court was able to give the child's consent, because the child didn't have the capacity to do it, which is, by the way, the default when the child is a minor. And it's just a question of evaluating capacity if they're an adult. So it would require some really careful consideration to make sure that the child is able. Now, that for some children, that's perfectly the case. So for people on the spectrum that are able to make decisions and just have less severe effects, that would be maybe appropriate. For people who have purely physical disabilities and are still perfectly capable to make their own decisions, again, that might be an advantage as a way to do it. If the benefit of it is trying to do things like avoid probate or get homeowners grants or principal residence exemptions, my advice is it just requires some really careful consideration, and it might not be worth the disadvantages to get those benefits.
Mm-hmm. Okay, thank you. I'm mindful of the time. I think we'll ask the last question, and just want to let everyone know that Geoff is actually coming back on June 9th and talk more about trust and trustees. So make sure that you do your registration early, because we will be closing the registration maybe a couple of days before the event. So please register. It's on June 9th, the same time, 10:30 to 12. And Geoffrey will talk more about trusts and trustees. So I will ask the last question from someone that asked about, can the grandparents roll over their RRIF to the disabled grandchild?
Yeah, that's a good question. And they can, but there is a bit of a trick there. You do have to show some financial dependency. So you do have to show that the grandparents have been doing some assistance for the child during the lifetime. When it's a parent, it's just assumed because they are usually living in the same house, or there's a pattern of doing that. When it's a grandparent, you do have to be a little bit more careful, because it's more likely that CRA would challenge it. And so you want to establish a pattern of some financial support. So I wouldn't want the person to go ahead and assume that that's going to work without getting some specific advice. So I will say it with that caution, that get some specific advice about it, but it is an opportunity that if it's carefully planned out, you might be able to take advantage of.
Okay, thank you so much, Geoff. Like it's 12 o'clock already. So before we end, I want the participants to know that we will send out the the slides from today's presentation to all the registrants, and also the video of this talk will be available when maybe after a couple of days. That I will just also let all of you know how to access it. It will be on our YouTube channel. And thank you so much, Geoff, for your generosity of letting us keep the video, so people that cannot come or want to watch it again can listen to you again. Thank you so
Sure.
much, and I will see you again on June 9th.
Sounds great. Thank you, Stella, for the opportunity to do this. Everyone have a great day.
Yeah. Have a good day, everyone. Bye.